we're really excited to have this panel because not only are these five the greatest experts in these things that we could find in the space, they're going to be talking about a lot of the stuff we've been talking about all day and how to avoid the legal pitfalls. It's going to be really exciting. Please join us. A round of applause for Mark Roderick, Amit Singh, Georgia Quinn, Jillian Siddotti, and Jor Law.
Do you think I should stand to moderate? You want a podium? Or would you like no, that's okay. Okay, let's see. No, this is good. Or maybe I'll just stand for the time being. Okay, thank you very much, everyone, for staying around for the most interesting panel of the day. I do want to say that, not to take anything away from Elon, but I did notice that this morning's panels were introduced by Jessica Van Stieg, and I was sort of hoping we would have that same treatment, but apparently not. Okay, so actually, the first thing I want to say is I'm Mark Roderick. I'm a crowdfunding lawyer. I do crowdfunding full-time, 24/7. I have a blog at markroderick.net where there's a lot of interesting information, and that's all I'm going to say about myself, except that I'm not dressed this way intentionally. There was weather on the East Coast last night. I don't know if anyone else got caught in it. So there was an 8-hour delay, and I flew all night, and they lost my luggage. So I'm not dressed this way because I'm cool. You can ask.
But you are so cool.
Ask both of my friends, and they will tell you I am definitely not cool. Although in Los Angeles, you know, if you're going to be dressed like this at a panel, this is the one place. You know, for lawyers, it's not that bad. On my way to the conference, there were a couple of car accidents, so I gave the people my card, and they seemed totally okay with that. All right, so I am not cool, but fortunately, we have 4 very cool panelists, and I'm going to let them just say a few words about themselves before we get into the substance. So very briefly, Jillian.
Hi, my name is Jillian Siddotti. I'm from crowdfundinglawyers.net, and it's pretty self-explanatory.
Amit.
I'm Amit Singh. I'm a partner at Stradling. Stradling is a full-service law firm with about 130 lawyers. I've been practicing corporate law for about 19 years, and I'm a corporate governance and business transactions expert, representing mostly technology companies and life sciences companies.
And Georgia.
Hi, I'm Georgia Quinn. I'm the co-founder and CEO of iDisclose. We're a legal technology company that helps automate the provision of all the legal documents that you need to operate your business. We started specializing in the disclosure documents that are required to be filed with the SEC. So we've automated the preparation and filing process, and now we're branching out into really any documents that a smaller startup business needs to operate.
Georgia is the CEO, I think, of iDisclose. That's the technology startup. She's also an excellent securities lawyer in her own right. So she actually wears 2 hats when she wears a hat. Jor Law.
I am a corporate and securities attorney with Holmeyer Law. I'm also the co-founder of VerifyInvestor.com, which is an accredited investor verification solution.
So Jor also has 2 hats. Okay, so just to get everyone on the same page, you know, there's a huge amount to talk about here. Last year in this panel, in 45 minutes, we talked about every single legal pitfall of crowdfunding. So this year, we're going to talk about every single legal pitfall of both crowdfunding and cryptocurrencies. So we have a lot to talk about, but you're never sure with any given audience where everyone is in terms of sort of understanding of crowdfunding basics or cryptocurrency basics. So to try to at least get everyone on somewhat the same page, we're going to start off with very brief summaries of the 3 flavors of crowdfunding. They have all different names, okay, and they often mean the same thing. But all of crowdfunding came about by the 2012 law signed into law by President Obama, the Jobs Act. And we refer to them as titles, Title II, Title III, and Title IV. And that's because when laws are passed by Congress, they are segmented into titles. So there's nothing, that's all it's about. Title II, Title III, and Title IV mean sections of the Jobs Act. So with that mini introduction, first, I'm going to ask Georgia to give us a very brief introduction of Title III crowdfunding, and I guess start by, for the first 20 minutes, tell us all the different names that it's known by.
Okay, so we're starting with Title III crowdfunding, sometimes called equity crowdfunding, sometimes called non-accredited crowdfunding, sometimes called
Regulation CF.
Regulation CF, Title III, Regulation CF, sometimes Regulation C. And you know, a few others maybe we'll come up with as the day progresses. But the basic hallmark of Title III crowdfunding is that it is to non-accredited investors through an online medium. So this is the ability for an issuer to sell securities in their company to unaccredited investors through an online platform, and they're able to issue up to $1 million of securities in a 12-month period. So it's a pretty groundbreaking sort of concept for securities law. I think for most people, they just think like, well, why wouldn't you be able to do that? So for those people, yay, we can now. One of the things that you need to keep in mind when it comes to Regulation CF, or whatever, we're going to just call it Regulation CF. One of the things you need to keep in mind is that you have to file certain documentation with the SEC before you can launch your offering. So unlike some sort of just rewards-based crowdfunding on Indiegogo or Kickstarter, where there are no real legal ramifications, you simply create your pitch page and you launch your deal. In order to do this type of offering, where you're actually issuing securities in your company, so debt, equity, a rev share, some form of actual investment in the company, not just pre-selling your product, you have to file what's called the Form C with the SEC. And this document has to be on file with the SEC for 18 days before you can close your deal. That's not usually an issue because it generally takes a lot longer than that for you to fill your commitments to your deal and get enough investors to meet your minimum amount. But these are, some of the legal ramifications that you have to go through before you can actually close and receive money from investors. In addition, you have to use a SEC registered online platform. So it has to be what's called a funding portal or a broker-dealer that actually has authorization from the SEC and FINRA to conduct these types of offerings. So if you're a company out there thinking about doing a raise, you need to make sure that the platform that you're planning on using is properly licensed. And again, the transaction has to take place on the platform. So if you have other investors that want to invest, offline or something, you need to make sure to direct them through the platform if you're using this Regulation CF exemption. Those are pretty much the parameters, and I think we'll probably drill down to more of the nitty-gritty as we get to the kind of pitfalls. But
yeah, you absolutely nailed it. No, really, she did. That was terrific. And the only thing I would add is you do file something with the SEC, but the SEC doesn't approve it. So it's not like the next thing we're going to hear about. The next thing. So you file it, but nobody needs to approve it. So it's a very quick process. Okay, Jillian is now going to tell us about Title IV crowdfunding, which is also called...
Which one is that again?
Yeah.
I'm joking.
Jor is going to tell us about Jillian, go ahead.
Regulation A. So Regulation A has existed since, pretty much since the Securities Act of 1933 has existed, but then when the Jobs Act came around, it completely augmented Regulation A and separated it out into two different tiers. I like to concentrate on what we call Tier 2 Regulation A crowdfunding. The reason why I like to concentrate on Tier 2 as opposed to Tier 1 is because Tier 2 specifically allows you to raise up to $50 million And you can take it from accredited and unaccredited investors, actually any investor for that matter. You can use general solicitation. You can get it listed on an exchange. There's a lot of flexibility there. The big but, if you will, is getting it approved by the Securities Exchange Commission. So you do have a process by which you have to take your prospectus and get that approved by the Securities Exchange Commission. What I differentiate Tier 2 from Tier 1 and why and I don't know if you have the same experience, Mark, but I prefer not to do Tier 1 offerings.
No one should do Tier 1 offerings.
No one should do Tier 1 offerings.
Period.
You've heard it here first. Because the reason is, and if you're ever thinking about doing a Tier 1 offering, is because you do have to take it to each and every state in which you want to raise money and get it approved by that state. And I will tell you that before the Jobs Act existed, I would do Regulation A's, and I would have them rejected, soundly rejected, no chance of resurrection whatsoever by certain states. So there's just no point of doing that. They're not going to change because the Jobs Act changed. They're still going to reject your offering. So you might as well just go Tier 2 and make it happen. And the big differentiating factor is an audit. And if you're a brand new company, an audit is not that hard to do.
Right. So the SEC actually has been very, very friendly in crowdfunding. And one of the many ways they've been very friendly is they really pushed the envelope when they came out with Tier 2 in saying that if you do Tier 2, you are exempt from state regulation. And that earned them a lawsuit from the states who didn't like that rule. But the lawsuit was dismissed. So yeah, so that's why we do Tier 2, zero state regulation. But you do, as Jillian says, need to go through the SEC approval process.
Right.
And is it your experience that the SEC has become bogged down recently?
Yeah, it's funny because I do a ton of real estate offerings. Most of my offerings are real estate. And there's, especially the real estate department, if I put in a tech offering versus a real estate offering, I will probably hear about the tech offering first, because the real estate department in particular is bogged down. And I've even gotten emails from the SEC as late as 11 o'clock at night. So I do think that they're perhaps, really putting in a lot of overtime. And I know personally, like, I might call an attorney at the SEC and I have to talk to them about 3 of my own files. That's just little old me. So I can't imagine how many files each attorney's actually looking at over there.
Okay, so Amit, now you are going to give us a brief description of Title II crowdfunding.
So Title II crowdfunding is called 506C. And so what it is you can raise an unlimited amount of money for an unlimited number of investors, as long as they're all accredited investors, and there's no specific disclosure requirements. But you have to verify that all the investors are actually accredited. And when we do the private offerings, 506B, we just have them self-certify. The investors say, I'm accredited for these reasons. My income is this, my net worth is this, and that's usually sufficient. Here you actually have to verify it. And that means that you have to go deeper. There's no specific requirements. The SEC has given examples, like you can look at their tax returns, you can get a letter from their accountant, things like that. And it poses a big impediment, because a lot of investors don't want to give some startup company all their personal information, their tax returns, et cetera. And so companies like yours have come up, and you have these companies that verify you separately, and then at least that investor is verified for lots of different offerings. They don't have to give all the information specifically to all the startups, so they can kind of dovetail off of that. Now, it sounds really great that, you have Regulation CF, you have to do this filing, and you've got Regulation A+, and you've got to do this massive filing. And here, there's no specific disclosure requirements. But that shouldn't lull you into a sense of security, though, because you still have to comply with the anti-fraud provisions. So you can't make any material misstatements or material omissions. And theoretically, you could be liable for, even if you didn't purposely, there was no malice or there was no fraud involved, you could still be liable. And it's not for any material misstatement or omission. if somebody actually lost money because you haven't done your due diligence. If it's something you could have discovered, then you should have disclosed it to the investors, especially if it makes them lose money. But to the benefit is that much like Reg A Plus, the Tier 2, it also preempts the state substantive blue sky laws. So you don't have to figure out what each individual state wants you to file with them.
Okay, so Title II is based on a premise that has been an underlying assumption of U.S. securities laws since the 1930s, and that is that rich people can protect themselves. So they can hire expensive lawyers like Georgia and Jillian, and they can hire accountants and they can hire investment bankers. Rich people can protect themselves, whereas non-rich people require the paternalistic arm of the government around their shoulders. And although it sounds, whenever I say that, it sounds sarcastic, that system has worked pretty well, actually, for the last 85 years. That's why Title II, accredited investors only, is basically wild, wild west. You can do absolutely anything. And so the question is, well, why would you use, if you can do anything with no restrictions in Title II, then why would you use either Regulation CF or Regulation A? Amit, you want to answer that question?
Yeah, so the big advantage is that you can get unaccredited investors, you can get the crowd, anybody can invest in your company. And then Regulation A+, in particular, you can have freely tradable securities. So you're able to conduct a mini IPO, and you can even eventually list your stock on an exchange, and it can trade. So it's a massive advantage versus here, you're only able to take money from accredited investors, and you have to actually verify they're accredited. So it's a lot more work theoretically to do the A+. I'm a big fan of A+ because you can raise $50 million, and although disclosure requirements are, it's relatively expensive. One big advantage of A+ is that you can also test the waters beforehand. So before you engage, some lawyer to actually spend $100,000 or whatever it's going to be to create all your offering documents, you can actually go out, seek indications of interest from potential investors and say, hey, look, we've got this company, this is what we do, we're thinking about raising money, this is the type of security, are you interested? And then if $10 million of interest is there, you say, hey, yeah, I'm going to spend $150,000 in legal fees, accounting fees, et cetera, to get this done because the money's there. And so you can actually, so I would probably, I would say that Regulation A+ is probably the most valuable exemption that came out of the Jobs Act.
Okay, so now I'm going to switch topics a little bit into the cryptocurrency world. And we're going to talk about the overlap between cryptocurrencies and crowdfunding, or cryptocurrencies and the securities laws generally. This is an issue of tremendous current importance because many of the cryptocurrency offerings that we've been seeing over the last few months have in fact been securities offerings and have been done without regard to the securities laws. So it's a huge legal topic these days, and I'm going to ask Jor, who's our resident cryptocurrency investor expert, to tell us about Mr. Howey and why Mr. Howey is relevant to this distinction between cryptocurrencies and securities, or the overlap, I should say. When is a cryptocurrency subject to all the securities laws that we are talking about?
God, I don't know about expert. I've been losing money the last 3 days. No, not today, but the weekend was not a great weekend. Look, really, around the world, people have been doing these ICOs, and they've basically been doing it and kind of claiming that they aren't securities. And kind of starting around the world, you're starting to get folks come out and say, look, these really are securities. And China did that, Hong Kong did that, Singapore did that, the US did that. And the question really first is it a securities or not. And there's a detailed test on how to analyze that. And I think there's a really good paper out there. If you Google, I think securities law framework for ICOs, you'll find a paper that was released out by Coinbase, and it's as an exhibit to it, a law firm called Debevoise had prepared an analysis. And I think that gives you more information than you need to determine whether something's a security or not. So rather than going to the entire test or not, I think the idea would be more, you've got two flavors of really ICOs and tokens, right? And some of them are true tokens in the sense that, I guess they're all tokens, but some of them are not securities because they're not tied to any investment motive. They're not tied to a profit that's based on the fruits and labors of other folks, right? And those are the true folks, those are the true tokens that are not securities at all. And then for everyone else, everyone who's really selling an item, a token on a basis that it's an investment, and that it could rise in value based on largely efforts of other people, those basically are all securities. And I think for today's discussion, that's probably the analysis that we would go with.
So let's see. Somebody calls me, and I would say, we have all these lawyers here. Within the last few months, probably like every other call we get is about ICOs, right? And so this question of is it a security or is it not a security, it's a very hard line to draw. But I guess I would say, to repeat but emphasize, that if what you're buying looks like an investment, smells like an investment, acts like an investment, you are hoping its value will rise based on what other people do. Or here's an example. Someone calls me and says, I want to raise money for my real estate project, but I want to raise it in the form of tokens. Okay, so people get a token, and what they really own is a piece of a multifamily apartment community. And the value of the token depends on the value of the real estate. Well, that's a security, right? Or I should say, yes, that is a security. It's just a digital stock certificate. And that's what a lot of the offerings these days consist of. But, Jor, give us an example of a token that is not a security, that clearly falls on the other side of the line. You probably own a bunch of them.
I don't know about clearly. Here's the issue, right? If you're investing in a company, if the tokens represent interest in the company or interest to profit streams or interest in revenue, almost certainly it's a security, right? So where the gray line comes is if the token represents a monetary unit within a closed universe, and that's all it is, then possibly it's not a securities. But if you start marketing it and you start saying, well, here, if you buy one coin, and this coin allows you to buy X amount of storage in the future, and by the way, if you buy this, you're likely to make money, and you'll make money out of it. You could accidentally transform something that may not have been a security into a security by the way that you're offering it. So, one example of a company that's trying to now do something that is a security and turns into something that's not a security, I think is interesting. It's called Filecoin. Filecoin did this tremendous raise where they raised about $200 million in about an hour's worth of time. And they did it through an agreement called Simple Agreement for Future Tokens. So the tokens don't exist, the technology is not proven. They basically went out and did a round where they realized it was an investment round. They basically said, invest in this because you have a right to receive these tokens in the future. And that's clearly a security because they're going out to people and they're saying, invest in this unit of economics, which gives you a right to obtain something of value later, which is going to be worth a ton of money. Now, the argument, of course, later is that when they go out and they actually issue out the tokens themselves, the argument is that they are not securities at all. The tokens have only one purpose. You can make them by having bought them, or you can make them by mining them, and then you spend it by saying, I want storage, here, spend it. And arguably that's not a security. So I think Filecoin is one of those interesting things where you could look at one ICO and cryptocurrency offering and see elements of securities on one half of the deal and then non-securities for the other half.
Okay. I'm just kidding. Yes, Georgia.
So one of the ways I try to explain it to people and just add some clarity to this whole picture is if it seems like the pre-sale of a product, like I'm selling you some file space, but I'm calling it a token, but it's really something tangible that you're going to be able to use in the ecosystem of my company, that's more likely not a security. So like, Mark, in your example of, I've got a real estate deal and I'm selling some interests in the real estate business and I'm calling them tokens. Okay, so that seems more like a security. But if those tokens actually got you the right to stay in that property for 5 nights a year, that's more like an actual pre-sale of a product. That's not a security. So it's just, really think about it. If it's something that you are buying something that's more like a product in that company or that company is going to produce at some point of time, it's probably not a security. But otherwise, like George's saying, if it's something that you're marketing as an investment that's going to appreciate in value, that's going to, be tradable and provide liquidity, that's a security.
Yeah, and that's an elegant way to put it. I mean, really, when you look at non-crypto space and you look at something like Kickstarter and its pre-sales of products or sometimes sales of products, those are not typically considered securities. But if you look at equity crowdfunding, where they essentially are selling interest in investments, then those would be securities. The same analysis would apply in the ICO space.
So having completely resolved that question for our audience, we'll now turn to something else. But obviously, the panel is legal pitfalls. So would you ever issue a token without running it by a securities lawyer? No, because it may well be. And as you can see, just from these fairly simple examples, it's often a terribly difficult line to draw. The point is there is a line. Until very recently, lots of folks were acting as if there was no line. Fortunately, the SEC, within the last few weeks, issued some guidance saying, yeah, there's a line out there somewhere, folks. So definitely, you don't issue a token without running it by a securities lawyer.
Well, also, I wanted to add that keep in mind that it's not just securities laws you have to worry about when you start issuing these tokens. If you have a token that's exchangeable for something else, like a security later on, it may be considered a swap. Is it a total return swap? Is it another kind of swap? And then you have to look at CFTC regulations. And then also, if it's really, you're creating a currency that can be used for other purposes, then you have to look at money transfer laws, money laundering laws, and all of those things. And so it's not just the issues we're talking about here. Obviously, that's the focus here, but just keep in mind that it is a more complicated, broader issue.
Okay, so now I'm going to ask Jillian to talk about one of, well, I always think it's probably the most significant legal issue in regular crowdfunding, and that is broker-dealers. Huge issue for all of us who work in that space. So Jillian, do you want to tell us what the issue is, how it manifests itself, and why anyone should pay attention?
Well, I guess in the context of that, you always want to, if you want to raise money for your deals and you want to pay somebody to raise money for your deals, that person has to be a licensed individual, licensed by FINRA as a broker-dealer. And one of the things I always run into is, I'm fascinated by the fact that there's a lot of people who run around out there saying, I'll raise money for your deals, just pay me a commission, and they're not licensed. And a lot of issuers get, stars in their eyes because they're all excited about having somebody raise money for them. But it's just like the sale of a house or a piece of real estate. You can't pay an unlicensed agent to sell that house for you. So you need to have a licensed broker-dealer. And then when you start throwing in the coins and you have cash, how does the broker-dealer get paid? And how are they reporting that to FINRA? And FINRA, so So the SEC is, kind of a scary organization. They're the government. They wield a lot of power, and they have a lot of rules, and they regulate. FINRA is a private organization that operates like a governmental organization and is way scarier than the SEC. So
We were going to have a representative from FINRA, but they are so scary that the conference organizers precluded us from having someone. So can I ask you, Jillian, typical crowdfunding portal. What do crowdfunding portals do? They help issuers raise money, whether it's real estate or something else. Typical crowdfunding portal sitting at the intersection between the folks who need the money and the folks who have the money. Does the typical crowdfunding platform have to be a broker-dealer? Are they broker-dealers? How does that work?
It depends, right? So there's I always like to differentiate between a portal and a platform. A platform, generally speaking, I believe runs under Rule 506C or perhaps Regulation A, where a portal runs under Regulation CF and those rules. And they have to go and get approved by FINRA, and they are kind of like this, they're called intermediaries. So they're regulated by FINRA.
She's talking about Title III funding portals.
Regulation CF funding portals. And I will tell you right now, in doing my own work on these Title III Regulation CF portals, the FINRA is very much wants everything to fit in a box, like a serious box. And if you don't fit into that box, you make them very nervous. They're very apt to want to say, look, this is not for us, you're not fitting our rules. And so that's where I feel like the coin is going to.
But what about a Rule 506C platform? A CrowdStreet, a Real Crowd, a Funders Club?
Sure.
Are these folks broker-dealers? Do they have to be?
No. No, they don't.
Okay, thank you, Jillian. Okay. Can you, why not? Aren't they putting together issuers with investors?
So in a lot of ways, yes, they are, but they're not being paid from the raise themselves. So that's where the difference lies. They're not getting a commission for the sale of the securities. They're charging you a fee to use their technology. So they're not regulated by FINRA. I'm sure FINRA would love to regulate them, but the way they're being compensated and the way they're holding themselves out, they are a technology company, not a broker-dealer. And their compensation is not tied to your success of raising capital.
Okay, and so if they charged a commission,
We're having
which they would love to do, right? Because that makes the most sense for any of these business models.
Right.
We'll help you raise money, we'll charge you 5%. But if they did that,
they'd have to be regulated by FINRA as a broker-dealer specifically. And that's a lot of work. It's a lot of work to comply with FINRA. So that's why you're not seeing a lot of the platforms operate on that model, because the compliance to do that is just not worth it to them.
and so let's say someday an investor, not that this could actually ever happen in the crowdfunding world, but let's say an investor loses money. And the investor has a brother-in-law, or I should say sister-in-law, let's say that, a sister-in-law.
You're so PC.
Yes, that happens to be a plaintiff's lawyer. And is it possible that that plaintiff's lawyer sister-in-law looks at these arrangements and says, maybe you should have been a broker? So, what could happen there?
So that's a great, so this is why it's important.
Finished. That was a great question.
That was a great question.
Thank you.
That's a great story, hypothetical, if you will. I'm pretty sure that's going to end up happening in some circumstance. But so this is what I tell anybody who comes to me who says they're going to start being a platform and they look kind of like they're going to fly by the seat of their pants, is that you better do some really serious due diligence on your issuers That's number one. Don't just let anybody on your platform. That's not good just to keep away from, plaintiffs' attorneys. It's good for business practice anyhow, because think of, I'll use CrowdStreet as an example. Think about CrowdStreet. If CrowdStreet allows you, somebody with no experience, and then, with somebody who has a property that's got some issues with it, onto their platform, and investors start losing money, those investors are going to start telling people on Bigger Pockets or other, message boards that, hey, guess what? I lost money on CrowdStreet. Don't invest on CrowdStreet. It's going to ruin their business. So that's number one. Number two is make sure that these issuers are indemnifying you as a platform. I think that's huge. And three, make sure that you're very agnostic when it comes to the marketing of the particular deal, so that when you are marketing the deal, you're having the same formula for each deal that you're marketing. It looks exactly the same for everyone. The marketing is nice, but it's not that you're promoting any deal on your platform over another deal on your platform, perhaps. So there's a lot of steps I think a platform could take to hedge against that risk. Anybody can sue you for any time for any reason, but let's see them have a successful lawsuit.
Let's not see them successful.
If you put these particular fail-safes in place, then perhaps they won't be so successful.
Okay, so we could talk a long time about broker-dealer issues in this space, but we don't have time. So Amit, can you talk about legal pitfalls specifically in the Regulation A space? What should people be watching out for? How can people get in trouble?
So I guess I would say that in all these spaces, whether you're doing a private offering, a public offering on one of these portals, you have 10b-5 liability. So a material misstatement or omission involved in the offering, then somebody can sue you if there was some kind of intent, some real fraud. But then when you get into doing these public offerings, there's also there's no scienter, no intent required in order to find liability. And then there's always, and then also it's a question of
what does that translate to?
What that means is that the investors can get rescission rights. They have the right to get their money back. And it can not be limited just to necessarily the issuer, but it also can be the other people involved in selling the securities. It can be the CEO, any people at the platform, et cetera. All those people potentially could be liable personally for an investor's loss under 12A2.
In the circumstances where they fail to disclose everything.
And there was no intent. They weren't purposely trying to trick people, but they didn't do their due diligence. They didn't go out of their way to disclose everything. So keep in mind when you meet the requirements of Regulation CF or Regulation A+, that's not necessarily enough. You want to make sure you've got risk factors, all the reasons why people are crazy to invest in your investment because they could lose their money. You need to list all those things, no matter how remote. You really look at, when you try to figure out if something's material, do I need to disclose it? You look at the likelihood of occurrence compared to the magnitude if it were to occur. So if something's only a 5% chance of occurring, but it's going to be a $100 million loss, even though it's very unlikely to occur, you need to disclose it. But if something's very likely to occur, but you're going to lose $10, probably don't need to disclose it.
And of course, all these, your diligence in disclosing stuff is by definition, when that sister-in-law brings the lawsuit, the business has failed. So all the stuff you thought was going to be really good about your business didn't happen. And the stuff that you didn't think could possibly happen, and therefore you didn't disclose it, did happen, right? So you are, in these plaintiffs' lawsuits, after the fact, things are magnified.
Right, and then also keep in mind that the broker-dealer issues that Jillian was talking about also come into play. Did you have an unlicensed broker-dealer involved in your offering? Boom, everybody gets their money back. they all get rescission rights. And then even though these like Reg A Plus, it preempts the state substantive blue sky laws, those are what we call issuer exemptions. So the issuer is exempt from having to do a filing in those states other than a notice filing. But people involved in the offering, let's say you have a third party marketing your offering, well, if there could be a state requirement that those people register under FINRA or whatever their registered broker dealer, and if not, then under the state law, people could have the right to get their money back. So it's relatively complicated, and it's not something that somebody without a lawyer could probably really navigate.
Okay, Jor has been texting me. He says, Mark, you're not asking me enough questions. So let me ask Jor a couple questions. We'll get past it. Jor, as has been noted, is the founder and CEO of a company called Verify Investor that does the verification for Rule 506C offerings. Can you tell us, Jor, what are you seeing in the market, sort of pitfalls around verification? Are people cheating? Are people lying? Is it being done right industry-wide? Are there some people that are not doing it right? Sort of what are you seeing on the verification side?
Yeah, it's interesting. It's kind of a space that it's horrible. Like no one should really want to do verifications or think that it's a great thing. It's bad for the marketplace. It's a bad law. But it is a requirement of 506C. And some of the observations I think out there are that a lot of folks that used to do 506B offerings and then switched over to 506C offerings, well, it turns out that some of their 506B investors are probably not accredited investors, right? So the math is always, how many investors will I lose versus how many more will I gain through this process of being able to generally solicit and advertise? And I think in general, what we see is reasonably positive. The volume of verifications do keep growing. I think we are the dominant accredited investor verification solution out there, used by almost every white label platform provider and by a lot of the crowdfunding platforms and a lot of issuers that are just randomly out there. So some of the insights I think we'll share are that first, crowdfunding is not necessarily a small person thing. It's not necessarily a small investor thing. There are large companies like Mercedes-Benz that are using 506C and doing crowdfunding to offer securities at very large dollar amounts. There are offerings where country sovereign wealth funds are investing in or World Bank funds are investing in. And these are offerings you might not always hear about because just because you call it crowdfunding, it doesn't mean you have to go to every person. You can just generally solicit and market to a smaller segment of the crowd, and it's still crowdfunding. So I think that's interesting to see. Lately, about a month ago, maybe every day, there's been at least 2 or 3 phone calls from folks that want to verify investors for a cryptocurrency offering that we didn't see before a month ago. For the last few years, we've been verifying folks that have had cryptocurrency as part of their assets. And I think the other thing to note is that your crowd and who you verify and how they get verified varies dramatically based on the type of company you are, the space that you're in. You could have an offering that appeals to older folks. You could have an offering that appeals to folks that are international. And depending on the demographics of the folks that you appeal to, their verification metrics and how fast they respond and how they get verified could drastically vary.
Are people at this point, so in the beginning of crowdfunding, the angel investing folks said, no one's ever going to invest, no one wants to show you tax returns, this verification thing is a complete dead end. And I think in the beginning, probably portals and issuers lost some investors along the way who just didn't want to go through the hassle. I haven't asked you this question for at least a year. So what are you seeing today from people who are transferred to your site to get verified? Do issuers lose a high percentage, or does it vary depending on the issuer?
So it's hard to say because we offer our service as a professional services company as opposed to kind of an internet company, so we don't really go data mine. So my response is based off anecdotal, off support inquiries and whatnot. So I think in general, in every type of offering, you get an indication of interest, which is extremely high, and by the time you get the money, a lot of people drop out. So I think that it's just a matter of where they drop out. So for the issuers that have the worst issuer ever on our platform, I think went out and told all around the world and told everyone can invest, even the little guys can invest. And then they sent us, a ton of verifications in a week, like thousands. And then subsequent to that, they emailed all their international folks and said, oh, never mind, our attorneys told you guys can't invest. So immediately all the foreign folks, stopped the process and dropped off. And then a lot of the other folks that came in and got mad and said, but they said anybody could invest. Why do I have to prove myself, right? So they had like a 50% failure rate. For the folks that kind of go through and say, and have proper documentation and say, look, this is an offering to accredited investors, and then someone signs a subscription agreement, and then they have a side letter or a click-through screen that says, look, federal laws require us to verify you. You are going to have to prove it. Do you still want to proceed? And someone says, yes, I know. I still want to do that. So you've highlighted the process to them, and then they put them through. We think it's about an 85 to 95% success rate. Obviously, for us, if someone
and are the other 10 lying? I mean, did the other 10 just get caught being untruthful as to whether they were accredited, or
no,
did they just decide they didn't want the hassle?
Some of them decided they didn't want the hassle. Some of them couldn't prove it. For someone that may invest in a lot of private securities or have a lot of illiquid securities or gold. Sometimes people try to verify off gold. They might not be able to prove the assets that they do have. A lot of times it's people that think they're accredited, honestly, but they're mistaken, right? For example, they're rich. They've amassed a lot of money, but they're investing through a trust. But the trust has other folks in it, or through an LLC, and their kid has 5% interest in the LLC, and then the LLC doesn't have $5 million. So they can accidentally think they're accredited just out of ignorance of the laws, but then when you have to prove it, they can't prove it.
I think I'm a billionaire. So, no, but that's interesting, because that's definitely a group that you're losing in 506C that you would not lose in 506B, because they would happily sign something that says I'm accredited.
Right, unless you did a 506B first and then followed it with a 506C.
Okay, Georgia, you've done a ton of Regulation CF Title III deals. What do you see as the legal issues in Title III, the legal pitfalls?
I think most of the legal issues are really more mechanical, because as we discussed, there are a lot of documents.
Do you want to take George's mic?
I think the battery died.
Okay.
That better? Yeah. Whoa.
Yeah.
Thanks. Okay, so I think for the most part with Title III, the issues we're seeing are really kind of more what I would call mechanical issues, just because there is a lot of regulation around the process, the procedure of filing. And so I think we're seeing a lot of just a very basic issue that a lot of issuers don't even realize is that in order to conduct any filings whatsoever with the SEC, you have to get filing codes. And in order to get filing codes, you have to file documentation with the SEC, and there's a process where you have to wait some time, and a human person actually has to look at a piece of paper that you've had notarized and then provide you with these filer codes, and that process can take up to 2 weeks sometimes. And so we get issuers that are ready to launch their deal, and they've done all their other documents, and they've built their page, and they have their video ready to go, and then they don't have these filing codes, and they can't, file their document. And so it's just a stumbling block that people don't expect to have. Other issues are, the filing of other documentation. So once you close your deal, you're required to file this document called the Form CU. And that just alerts the SEC and the public that you've closed your deal and tells them how much money you've raised. A lot of people didn't know they needed to file these documents and weren't filing them in the early days. Similarly, on an annual basis, you have to file a document called a Form CA, a Form CAR. And that just tells the SEC kind of how the company's doing after it's conducted its raise. So again, this year, we actually had companies that had had successful raises within the year, and like 50% of the people didn't even know they needed to file these documents and didn't. And so these are things that the SEC is noting and kind of following up on. Other issues we're having are with the actual disclosure that's being filed, so the Form C. There wasn't actually just a required format that the Form C had to be in. And so a lot of people were filing a lot of different pieces and screenshots of LinkedIn pages and just a lot of different information that they were kind of cobbling together to fulfill the filing requirements. And that's really not the appropriate way to meet the SEC's requirements. And so the SEC is kind of coming in and cleaning some of that up and explaining the way they want the process to really work. Some other issues have just been with the portals and the type of advertising that they're able to do. So you may have heard people talking about this concept of general solicitation. General solicitation means that you can just solicit anyone. You can put any sort of advertisement out at all about your company and the fact that you're raising money. And although you can offer your securities on this funding portal in Regulation CF, it's not considered a general solicitation, and you can't really do a full-blown general solicitation. There are certain rules around the things that you can and can't say, and they have to be limited to either specific deal elements or more just describing your business. And so a lot of people kind of ran afoul of those rules in the beginning. I think what's good about where we are in the market, and we've now had over 475 crowdfunding offerings, what we're seeing is that people are generally trying to comply with the rules, and as the SEC comes in and provides guidance and kind of helps, people are complying. So I think that's a really positive thing for the industry. And again, I really would point out the more foot-faulty type legal issues as the real, as what we're really seeing, and less of like people just like out and out fraudsters. I think what's kind of great about what we're seeing happen is the companies that are probably out and out frauds aren't getting funded. Like the crowd is just not investing in them, which is kind of the point.
Okay, so now I'm going to very quickly, because we are almost out of time, and I want to at least take a couple of questions if anyone has them. But I do want to focus just for a moment at the tail end about the regulation of cryptocurrencies. So I'm going to do this because we're right at the end, and we're right at the end. I'm going to ask a very leading question of my panel, and I guess it's a leading question for the audience. Do you think that while cryptocurrencies are highly unregulated today, and indeed we've heard panelists this morning in particular talk about one of the key values of cryptocurrencies as being they are unregulated, they are free from government restriction. Do you think there's any chance in the world that as cryptocurrencies and blockchain technology becomes more and more significant in our economy, that the government, the folks with the guns, are not going to regulate cryptocurrencies? Do you think this is just going to be the one thing that's not regulated in our society? I mean, and how do you think that regulation is going to play out? Very briefly, obviously, I'm not asking for technical legal answers, but just based on, lawyers basically deal with regulated industries. How do you see this playing out with cryptocurrencies? And anyone can raise their hand and
I'll start.
Jillian.
Obviously the SEC's already said they're going to start regulating. They've warned everybody that, look, this is a security, so buyer beware, issuer beware. This is a security and we'll come after you. And I think it's just a matter of setting like the government loves to set examples. So they'll set some examples and then they'll make the rules from the examples.
Okay.
That's how we got Sarbanes-Oxley.
That's for cryptocurrencies that are securities. What about cryptocurrencies that are just cryptocurrencies? Are governments going to allow their citizens to deal with currencies that are wholly unregulated?
Yeah, based on your leading question, and I think it's sort of obvious, I think the answer is they're definitely going to be regulated. It's a question of exactly how they're going to be able to regulate it. Bitcoin and Ethereum, the benefit is that it's just a crowd that's handling it, so it's difficult to regulate it right now. But if you want to turn it into cash, actual dollars, then it's easy to regulate. the tax code already covers barter transactions. So you can't just sort of barter and avoid, just because you're not using cash, avoid paying income tax theoretically. It'd be hard to catch you, but our tax code already contemplates that. And so clearly this will all be captured as well, that because you got paid in Bitcoin or whatever other cryptocurrency comes up, that somehow that's not income. Eventually they'll be able to keep track of it, they'll figure out a way to track it, and then a way to tax it.
Okay,
and then
so-
to regulate it.
But would it be hard to find? I mean, isn't the point that it is so transparent and we can trace it and track, and that's what the blockchain's doing? So I think it's going to be fairly easy to track.
And is it a good or a bad thing
regulate.
that cryptocurrencies are going to be regulated?
Well, I think
Or is
that
it
it's
both good and bad?
I think it's relatively neutral. I think that it's okay that it's regulated. I think the real benefit is you're eliminating the banks and the other third-party intermediaries that are charging these big fees. I think it's okay that it's regulated. People are taxed for being paid in cryptocurrencies. But the big benefit is the transactions are very cheap. It's not free, but it's much cheaper. So using a credit card and all that, all those companies are at risk. And that's why these banks have actually gotten together and created their own cryptocurrency, because they realize, ooh, this is a risk. We need to actually be on top of this and figure out a way that we can make money from it.
I mean, I think that's a fantastic point, and I'll just say this is an overlap of crowdfunding and blockchain. Why are they both valuable? Because they squeeze inefficiencies out of the market. They make things cheaper for consumers. So I think that is just a fantastic point. That's the value. They make things more efficient. Georgia, is it good? Is regulation good or bad?
I think it's a little of both, like we said. I mean, I personally hate regulation, but I'm willing to.
Would you buy a car if you didn't know that cars are regulated by the government?
That's a trick question.
It's just so unfair.
They pay me
All
to
this
ask
from a guy
trick
wearing
questions.
flip-flops. You know what I'm saying?
Would you
There's an excuse for that.
would you buy stock on the New York Stock Exchange if the New York Stock Exchange were not regulated?
Mark, I think regulation will come, as it's already coming. I think it's good in the sense that someone's going to try to regulate. We're kidding ourselves if we don't think it's regulated. It's always regulated, even if it's just self-regulated through the developers and the community, right? But the idea, I think, is very similar to crowdfunding. The first set of laws that come and regulate it might not work for it. It'll kind of put a damper on things. But over a period of time, I don't think blockchain, Tango, any of this crypto technology is actually going away, and it'll be up to the governments to find out a way to change the laws to adapt to it. The U.S. is probably not going to lead here. It's probably going to be some other countries that lead and start taking the business and commerce and finance away, and then the U.S. starts saying, oh, crap, we got to do it too.
And to the benefit of cryptocurrency, the fact that it's already gotten so big and we've been able to watch it in this kind of, I think it was Amy Wand who discussed this sandbox concept, that we've already been able to watch it and see how it operates before moving into regulate, I think is going to be so beneficial. I mean, that was a huge problem with crowdfunding. We didn't let anybody do it until we created these rules that are completely inefficient, and now we're trying to fix the rules to allow
Okay.
more efficient crowdfunding.
And I'll just say one macro thing. So what happens with laws is that governments through their legislatures respond gradually and slowly to the needs of the business community. That's why we have all these different forms of organization. It's why we have crowdfunding. And I think what's going to happen with cryptocurrencies is that slowly, the laws will accommodate themselves to the legitimate needs. Now, do we have time for any questions?
Yeah, you have a couple minutes. Go one.
Okay, one there in the front.
Question. I know on Reg A plus, it's a tradable, you can trade, right? Based off your, whatever shares you have. But for regular CF, when does it become tradable?
I'm not sure if everyone heard that. When do the securities issued in a Title III crowdfunding raise, when do those securities become freely tradable? Georgia?
So technically, the securities become freely tradable a year after you hold them, and tacking applies. So if you've been able to transfer them in a acceptable sort of transfer up to that point. It's still can be a year. But there are other issues around that because right now, at least, we don't have any sort of marketplace where you can list these and have a transparent exchange. Exactly, we don't have any exchanges. And also, there could technically be some state transfer laws that might apply because while the actual initial sale of the securities was exempted from state regulation, a secondary sale may or may not be. So there's a lot of questions around that area.
Yes, sir. Yes, sir.
In the gray area.
Excuse.
Raising Reg 3 or Title 3.
How much is the cost to the issuer of raising money using Title III? Well, that is a great question, and I think the answer is going to be it is all over the board. But does anyone here have a gut feeling for what the average total cost to the issuer? I think, yeah, does it cost them $15,000, $20,000?
I mean, it depends. Are you including the fees that you're paying to your the funding portal? Because the funding portal is going to take a percentage of what you raise. So that's really based on how much you raise. They're going to take between 3 and 7% of the amount you raise. Then you're going to have your legal fees, which can be anywhere between $2,000 and $10,000. Then you can have your accounting fees, your audit fees, which can be, again, anything between $2,000 and $5,000 to $10,000. So it really depends on your company.
And this is a key question for Title III. How do we make it affordable for these small issuers? We haven't figured that out. Yes, sir.
Is there a way to use real estate as kind of a hedge against blockchain technology or against Bitcoin? Is that possible? Is that something that's thought about?
Oh, yeah, it is definitely thought about. Do you want to answer the question?
Yeah, I have a couple of clients who are looking at doing that right now. So it hasn't certainly been perfected. Perhaps you have some insight
Oh,
that
I
I do not.
perfected it, yeah.
Oh, did you?
No, it hasn't been, yes. The idea of having some real hard asset sort of underlying the token is, whatever that asset may be, is definitely being thought about a lot. And there's a lot to say about it. We can talk afterward. Yes, young lady.
My question is, there's all this uncertainty about ICOs, and with the Dow decision that the SEC report they put out, they basically said it's a facts and circumstances test, and which means, I mean, for all of us who are attorneys and practicing, that is very profitable for all of us, but for those of the serial entrepreneurs in the room, it's not a workable solution. Blockchain or cryptocurrency gets rid of those, gets those efficiencies. It's also boundless in terms of, outside of the country, et cetera. Why not just have the SEC start to put proposed guidance or a proposed rule out there to put some rules of the road out there? Because right now you have things like you invest in a coin, to invest in another coin, to invest in another coin. And if there was some rules of the road, wouldn't we actually have...
Well,
I think you're the best person to be working on this.
The rules of the road exist, though. There's a whole body of case law about what securities are. Now, how...
You gotta hire someone. You can't just, you don't have, clarity.
A lot of interesting things are, the early adapters. Hey, I wish there were more rules, but those rules are going to be worked out, and the folks that work them out sooner and better are probably going to make a lot of money. And I'm not talking about the lawyers. Yes, sir.
I just wanted to say on behalf of everyone here born before 1990, I guess.
That's not me, but he's talking to everyone else.
I wanted to say thank you for the first clear explanation of the day about the crypto stuff, because I was lost and I'm getting a little closer now, so thank you.
Oh, he's thanking our panel for explaining the cryptocurrencies. I think maybe, should we...
And I'm not alone, but I had a question. I was wondering if you gave a couple of super clear explanations about this is good, this is bad. Could we do like a 60-second primer on the whole advertising for CF? Like you can't say anything before you go out. Once you're out, you can say this, but not.
Do we have time for that? I mean, I'm certainly happy to...
Now let's do that and wrap it up because we are...
Okay, we're going to do Georgia is going to do a 60-second primer on what is and what is not allowed in advertising.
Right.
I'm trying to take up some of her seconds here, but in advertising for a Title III issuer. Go.
Okay, so you are not allowed to do any form of advertising whatsoever before you actually launch your deal. That means you have your Form C on file with the SEC and your deal goes live on the site. Once you do that, you're allowed to do one of two types of advertising. A terms advertising, which can list only the name of the company, the amount of money you're raising, the offering deadline, the type of security you're issuing. That's it. Or you can do an advertising that lists the company, talks about the officers and directors, says generically that you're raising money, doesn't say how much, doesn't say what type, and directs people to the platform. Actually, both types of advertising have to have the platform website so that people can go. But one is like a more generic description of your company, your business plan. It can have videos about what you do, very, like open-ended. The other is what's called more of a tombstone ad, which has to have just the very bald-faced terms of the deal.
And is this, they can't be combined in one ad, or you must choose one path or the other for the whole campaign?
You could do one on your Facebook page one day and one on your Facebook page the next day, but you can't do them both on your Facebook page side by side on the same day.
Wait, we got to make a note for next year. Let's try to get someone who actually knows about Title III on the panel for next year. So I want to thank our panelists. I want to thank our audience for sticking around late on a Wednesday afternoon. Thanks very much, folks.
And thanks to Mark, because he looks great no matter what he wears.